Classified Crime is on the case of Sarah Boone, and today we're going to look at some of her 2024 and 2025 family court documents. If you are following along with me in this family court recap series, this is the beginning of part 6. I have broken it into parts because, as you can see, there are many documents to go over. So we're going to start with the three things that were uploaded in 2024. We ended here with the order for withdrawal of counsel being granted for Banquet in November of 2023. And we're going to move into March 2024 and then June 2024. And then we'll start with 2025. Now, if you're following this case, of course, you know that they just had the final hearing and we're still awaiting final order from Judge LaShonda Jackson. If that drops, that video will come out first, but I will continue to go over all the 2025 documents in the meantime. And of course, I have also released the closing arguments already because I know you wanted to see that and I didn't want to wait for them to come out in order. So some of it is a little bit out of order, but if you're following along with this, the parts 1 through 6 are in order sequentially. The other things that I released didn't have a part number to them, if that makes sense. So those are out of order, but when I get to them in the 2025, I will go over them again here. So if you're just following along in order, you can continue to do so. All right, so let's look at March 5th. All right, this was filed 3/5/24 in the Circuit Court of 9th Judicial Circuit and in Fort Orange County. I'm sorry that this page is crooked. The rest of them are not, so just bear with me. Brian C. Boone, petitioner, Sarah K. Boone, pro se respondent. Motion for court orders, parentheses 2. So there's 2 motions to obtain and preserve evidence for pro se respondent to provide court. So she is asking the court to give her the evidence so she can provide it to the court. So give me something I can give you, is how I'm reading that. Per Florida Family Law Rules of Procedure of 2023, Rule 12.2, Case Management and Pretrial Conferences, schedule or hear motions related to admission or exclusion of evidence, and per Florida Family Law Rules of Procedure 2023, Case Management and Pretrial Conferences, consider any agreements, objections, or form of production of electronically stored information. Comes now, Sarah K. Boone, pro se respondent, submits her request to the court for her aforementioned motion to be approved, generated by the court, and received by pro se respondent to submit to instructing previewed corporal and sergeant of the Orange County Corrections Department to receive admissible evidence against Brian C. Boone, petitioner, in the form of electronically stored information on tablets in all messages sent from pro se respondent to petitioner. 2, telephonic recorded calls made to petitioner from pro se respondent. Now, if these did get entered into evidence, you know I would be requesting them, and I have been. But as we'll see, I think the judge is denying this because they've told her multiple times when she's requested documents from the court, the process for receiving those is that you have to pay for the copies. You do not get to just get them for free. So she's not able to access them online because she can't figure out how to have access to the non-public, and she hasn't figured out how to submit a form so that she can access it. And she thinks that the court should just be giving her paper copies like she was able to demand in her criminal case. But you can't do that. You have to pay. There's a per page charge, and you have to request them on the appropriate form. And they've told her this before. Right. In preparation for a proposed case management conference to be requested by pro se respondent. So she's saying she's going to ask for case management conference. These messages and phone calls are necessary to be received prior for the pro se respondent to properly conduct, uphold, and apply to her defense for topics included to be addressed. Sarah K. Boone, pro se respondent, has attempted private cooperative resolution with Brian C. Boone, petitioner, numerous times prior to this motion and requests, and ongoing now for more than 4 years during her temporary incarceration. After repeated unsuccessful resolution and relief being sought to date by pro se respondent from petitioner, and the disobedient, unlawful, inappropriate actions, statements, and comments still occurring by petitioner against pro se respondent, clarification, remedy, proper solidification are requested to avoid further confusion and increased difficulty for pro se respondent Sarah K. Boone being inflicted deliberately and unnecessarily by petitioner Brian C. Boone. Wow. So she's saying that the petitioner is disobedient, unlawful, and inappropriate in his actions, statements, and comments. They're still occurring. She wants clarification to avoid future confusion and increased difficulty for her being inflicted deliberately and unnecessarily by the petitioner. At least say what actions or statements a judge would need to rule are unlawful. She just says they're unlawful, inappropriate actions. What are those actions? This is a motion, so you have to be specific, I would think. This is especially important to pro se respondent to be clarified and ordered immediately, as there is no scheduled trial date in her criminal case, where all factors regarding her livelihood and welfare now and futuristically with her son also are being based on presently and ongoing. So she used 4 different adjectives about time. So her welfare now and in the future, futuristically, being based on presently and ongoing. Now, the judge has already ordered on this. The judge has already, we looked at it last video. He's already said something about this. We looked at it in her closing statement too. In April 2023, I believe, is when they made mention of that if she wanted it ruled on then, they would have to take into consideration her incarceration status. If she wanted the ruling, it would have to be based off of her being incarcerated. Now she's saying because there's no scheduled trial date, they need to figure this out. Well, then you're forcing them to rule on everything in your parenting plan and all of that based off you being incarcerated. All parties, including the judge, petitioner, and the attorney for petitioner, have futuristically predicted and conceived this trial will and is going to happen. One thing about narcissists is they don't like to accept impending doom for themselves, that it is going to happen, because they're not just going to wipe it off the books and say, never mind, go home. They know eventually it's going to happen. There is no exact or specific date of said trial, and the ongoing avoidance, lies, self-appointment, and hindrances petitioner in everything pro se respondent is still trying to achieve, complete, order, obtain, and schedule should not be lawfully continued, will not be tolerated by pro se respondent any longer and ongoing. Any longer and ongoing achieve the same thing until the unknown conclusion of her criminal case. So she's saying this will not be tolerated by pro se respondent any longer and ongoing until the unknown conclusion of her criminal case. So you're saying rule on it based on your incarcerated status then. Best possible and all available resources should be lawfully allowed, enforced, and utilized by the pro se respondent regardless of the unknown outcome and in the meantime of your trial. You should have put here. But they told you that they wouldn't do that until A, the final hearing of the family, the modification motion, and B, the end of your criminal case. The court has already told you that. Still active marital agreements and rights for this case are presently in full effect for both parties. No, because a modification has been filed. Why can't you comprehend that? They keep telling you that. Pro se respondent is attempting greatly to use the agreements and rights effectively, but is unable to do to petitioner not allowing, ignoring, or abiding by. No, he filed a modification. He's waiting for the hearing. The hearing is postponed until your criminal trial is resolved. That has been said over and over and over. Wherefore, Sarah K. Boone, pro se respondent, respectfully, that's questionable, requests that this honorable court please grant this motion. What would they even be granting? I don't even understand what she's requesting. Make him stop being unlawful and give her some messages so she can prove her point that he's not taking her calls. He admitted on the stand he's not taking her calls. I don't think she needs all of that. We would like to have it just so we can make fun of her, but we don't need that. Grant this motion and enter its order to provide court orders, in parentheses 2, the number 2, to obtain and preserve evidence for pro se respondent to provide court to be used forthcoming in this case. Forthcoming in this case. Thank you, Sarah K. Boone. And then she has her certificate of service that she provided a true and correct copy sent via U.S. mail to herself, Judge Michael Dean, who was the one who wrote the last order saying that they had to wait, Joshua J. Martell, attorney for petitioner. And that's the end of this. This is the order denying her motion for court orders, filed 3/5/24 as well. And it says, this cause having come before the court on respondent's motion for court order to obtain and preserve evidence for pro se respondent, hereafter referred to as motion, and the court having reviewed the motion and the court file, hereby finds and orders as follows. So they not only did they review her motion, but they went back in the file and saw all the times that they told her that they had to wait. Meaning they looked back in the file at the amount of times they'd already explained this to her. 1, the motion lacks a specific legal basis for the relief requested. As per Florida Family Rule of Procedure, a motion must state with particularity the grounds upon which it is based and clearly set forth the relief or order sought. Respondent only cites 12.2, which is not a legal basis for the relief requested. Consequently, in accordance with Florida Family Rule of Procedure 12.1, the motion is hereby denied. Ordered in Orlando, Orange County on the 4th day of March, 2024. And their certificate of service to Brian, Sarah, and the attorneys of record. All right, this is Sarah Boone's request for initial disclosure, and it was filed 6/27/24. She wrote it June 18th, 2024. Initial disclosure, a party's required provision of basic information to the opposing party. So she's defining initial disclosure to the family law attorney for Brian. Initial disclosure is the mandated disclosure of required information by one party to the other, usually within 30 days of entry into the action and without waiting for a discovery request. Attorney Martell. As a pro se respondent in my case, and per Federal Rule of Civil Procedure 26, initial disclosures, in general, I am requesting all documents contained therein, such as. So now she requested the court provide her all the documents, and now she's demanding that the other attorney give them to her. Why does she? Okay, I guess that's like part of the. This is the way she's numbering with the letter I and then 2 I's. Okay. I, the name, and if known, the address and telephone number of each individual likely to have discoverable information, along with the subjects of that information that the disclosing party may use to support its claim or defenses, unless the use would be solely for impeachment. She's kind of using like a hybrid cursive writing here. It's a little harder to read. 2, a copy or a description by category and location of all documents, electronically stored information, and tangible things that the disclosing party has in its possession, custody, or control and may use to support its claims or defenses unless the use would be solely for impeachment. So she's literally writing word for word this rule of civil procedure that she is quoting here, this federal rule of civil procedure. She's listing all this out word for word because this doesn't sound like her writing. This sounds like she's copying it. 3, a compilation of each category of damages claimed by the disclosing party, who also must make available for inspection and copying as under Rule 34 the documents or other evidentiary material, unless privileged or protected from disclosure, on which each computation is based, including material bearing on the nature and extent of injuries suffered. Okay, C, did she have a B? There was an A. A was here. Where's B? Here's A. And then she had 1, 2, 3. Now C. Time for initial disclosures. In general, a party must make the initial disclosures within 14 days after the party's Rule 26F conference, unless a different time is set by stipulation or court order, or unless a party objects during the conference. That initial disclosures are not appropriate in this action, and states the objection in the proposed discovery plan. In ruling on the objection, the court must determine what disclosures, if any, are to be made and must set the time for disclosure. Please note, I am requesting 3 copies each of the following, in addition to the initial disclosure, if not already included, and specifically from the documents delivered to me via service of process. Now, I'm not sure if they're required to mail them directly to her or just post them on the docket, but seeing as how she allegedly can't access the docket, I would assume they would mail her whatever they're required to mail her. But this is her list of demands. 1, filing number 147523857, e-filed 4/12/22, and then she lists the time as well. Supplemental petition for modification of final judgment, signed by Brian Boone, date February 18th, 2022. 5 pages, including certificate of service. Oh, so she does understand about 5 pages, including certificate of service. Boom. With my delivery address incorrect. 2, not filed to date. And this is kind of in all caps here with her handwriting. I was never provided a copy of this as stated in the supplemental petition for modification. Then she goes back to her cursive. Joint stipulation for modification, signed by no parties, blank, date unsigned, blank, pages 5. Does that make sense to anyone at all? Filing number 166745431, e-filed 2/14/23, and the time, petitioner's verified petition to relocate. Now, she went to this hearing in person. She already knows the results of this. Signed by Brian Boone, February 13th, 2023. Pages 5, including certificate of service. Here it is again. Boop, boop, boop. You understand a 5-page limit, including a certificate of service. With my delivery address again incorrect. Please ensure the correct copy of this is sent, which include your predictions of my release from prison, page 2. You must, this is in quotation marks, you must include the opposing party in your correspondence to the court. Emails received without the opposing party included will not be addressed. I'm not sure who she's quoting. Oh, here we go. This statement, the cursive is getting worse. This statement was made to you by the Judicial Assistant Henrietta Coffey of Judge Michael Dean, 2/27/23, to ensure my rightful inclusion in my case. So maybe she's saying this was made out loud in the court hearing. Please ensure my address is correct as incorrectly stated on both summons I received and am requesting documents. But you still said you received them. So they were served to you, even if the address was incorrect. And am requesting documents from in addition to the initial disclosure. My temporary address has also been incorrect on numerous documents you have filed in my case, such as the notice for trial I never received and could not properly prepare for. Trial by ambush, quote unquote, is unfair and happened more than once. This is important. This is important. Here is my correct address. Sarah Boone, and she lists her correct address. Again, this is important. I am trying to prepare for this case properly, fairly, more efficiently, expeditiously, and economically. Not with all these adjectives, you are not being efficient or expeditious. Your cooperation will only add to this even greater. Your understanding of my lawful inclusion and advanced knowledge of your client's quote-unquote evidence will assist me. But the attorney for the opposing party is not trying to assist you. They're trying to oppose you. And then she lists her correct address again. Copy of letter request sent to the judge. And here's the envelope. Legal mail. Postmark 21st June 2024. This is a notice for non-jury trial filed 2/11/25. Comes now the petitioner Brian C. Boone by and through undersigned counsel and notices this action for non-jury trial, and in support thereof would respectfully show the court: 1. This action is at issue and ready to be set for trial. 2. On August 11th, 2022, an order on motion to dispense with mediation filed on July 26, 2022, was entered by court granting said motion. 3. The estimated time required to try this case is 2 hours. And there's a certificate of service to the address below provided by her via U.S. mail to pro se respondent Sarah Boone. This was also filed on the 11th of February. It's just a cover sheet that Joshua Martell filed showing that a motion to dispense with mediation was granted by the court in August 2022, and mediation of the issues would not be appropriate under the circumstances of the case. Sarah references mediation later on in the family court trial, so just keep this in mind for later. This is an order setting case management conference filed on 2/26/25. It's basically just telling the details of the hearing, that they set March 26th at 9:30 via Zoom, and that it is to last 15 minutes, and they provided certificate of service. This was filed 3/12/25, and it is a motion to appear telephonically and or by Zoom. Comes now the respondent Sarah Boone pro se, and moves this honorable court for an order allowing her to be present via telephonic communication and or by Zoom conference for the scheduled hearing in the above referenced case number. In support of this motion, respondent states the following. 1. Ms. Boone is incarcerated in the Florida Department of Corrections and is currently housed at the Lowell Correctional Institution main unit in Ocala, Florida. 2. Respondent was informed by a third party that a case management conference has been scheduled in the instant case. Said hearing is to commence on March 26, 2025 at 9:30 a.m. It should be noted that respondent has received no notice whatsoever from the court or the opposing attorney regarding the scheduled hearing proceeding. 3. Respondent states that she has a vested right to be heard in court. However, as a ward of the state, respondent is at the mercy of the DOC in her appearances at any and all court hearings. She will not be able to be present for any instant hearings of her own volition and does not wish to lose her opportunity to be heard in court. She would like to attend telephonically and or by Zoom and participate in these/all proceedings. In order for Ms. Boone to participate telephonically and or by Zoom, this court will need to enter an order directing the Florida Department of Corrections at Lowell Correctional Institution main unit to make her available on the date and time of the scheduled hearing at the classification department. And then a copy of this order must be provided to the Lowell Correctional Institution main unit And attention, Ms. Harvey. 4, to ensure the respondent's ability to participate in the upcoming hearing, this honorable court will either have to call Ms. Boone when the hearing begins or direct the main unit classification department to call the court at the appointed time and allow Ms. Boone to participate via telephonic means and or by Zoom. This is the only way the respondent will be able to appear and participate in the March 26, 2025 scheduled hearing. Wherefore, the respondent, Sarah Boone, requests this honorable court to grant this motion and enter an order allowing her to participate in the scheduled hearing via telephonic means and or by Zoom, and to provide the Lowell Correctional Institution Main Unit, attention Ms. Harvey, Classification Department, with a copy of the order directing them to make Ms. Boone available to receive this court's phone call or to call this court on the scheduled date and time. There's a certificate of service and her address. Now, it's interesting to note, she later, when they actually have the final hearing, she requests to be there in person and says that being there by phone would be a hindrance to her. I don't know if she wanted to appear by phone because of the short notice and she didn't think they would, I don't know. But this time she's saying she needs to participate by phone. Later on, she says that participating by phone would be a hindrance to her. Go figure. Now we have an interesting turn of events here. This was filed on the Clerk of Court's website on 3/13/25. It is a return to sender envelope mailed to Sarah Boone at the correct address. I've redacted it, but I did look it as the P.O. box that she listed. Returned to sender, refused, unable to forward. I don't know if that means the jail or the prison refused it or what, because I would think they would be the ones receiving it, not Sarah directly, but it says refused, and this was the case management conference notification. So just a little interesting detail there. I wonder who refused it. It will likely be the prison. I don't know why they would have, but that got returned. The motion did say that the judge sent it to 2 addresses, one being the street address of Lowell and one being this P.O. box. So she mailed it to both. So this is the only one that got returned. Okay, buckle up for this one because it's quite long. There are also some attachments or exhibits that she attaches. She filed this on March 20th. Comes now Sarah Boone, representing herself pro se, respectfully moves this honorable court to review the following. Normally when we see the legal document, there's a title at the top like motion for whatever they're asking or notification setting hearing, but this has no title. It's just asking the court to review these things. So 1, background and procedural history. So you're asking the court to look through the entire docket. 2, reconsider contempt of court continuance, and to sanction petitioner and his counsel. So they want them to reconsider this again. She brings this up so many times, and sanction the petitioner and his counsel. So basically slap them on the wrist for being in contempt. Enforce child custody agreement for sanctions and for relief due to parental alienation. And she has attachments that she feels like prove parental alienation. In my opinion, they just make her look more unstable. Now, they cannot enforce the child custody agreement as it stands as she is incarcerated, because the child custody agreement is that he spends 50-50 time with each parent. So how would that work? Enforce alimony obligation and recovery of property. So this, they've already said they can't rule on because Brian filed the modification and the modification hasn't been heard. But for some reason, she keeps insisting that they go ahead and do it, even though Judge Dean told her, well, if we go ahead and do it, we're going to have to take into account your incarcerated status. Now, at this point, she is already done with her criminal trial, so maybe she's saying look at it again because of that, but I doubt it. 5, grant a continuance on March 26 case management hearing, pretrial discovery submission requirement, and grant attorney's fees and costs. So this is confusing. Obviously she's going to go into it, but she wants a continuance on the case management hearing that is scheduled in 6 days from the date she filed this. And she wants more time for pretrial discovery submission. Now, attorney's fees and costs. The only attorney in this case is Brian's attorney. So is she saying to grant Brian's attorney's fees and costs request, or is she saying that she should get it because she's representing herself? It does not make sense for her opposing the petitioner to say grant his attorney's fees and costs, because that would be detrimental to her. So I don't know why she's even bringing that up. But we'll find out. This is a long one. 1, background and procedural history. The following history includes the essential events relevant to this motion and is also limited due to respondent having no access to her file. So she's reiterating that she can't access her court files that she's asked them to give her copies of. A, final judgment was entered in the case Boone v. Boone, and she lists the case number on June 15th, 2018, which incorporated the marital settle agreement and parenting plan dated May 3rd, 2018. Yes, it was. However, you were not incarcerated on May 3rd, 2018, so you cannot enforce that parenting plan anymore. B, on February 25th, 2020, the respondent was arrested and incarcerated in the Orange County Jail, which is the whole reason for the modification. C, following the respondent's incarceration, the petitioner ceased making court-ordered alimony and child support payments agreed to under the marital settlement agreement. She doesn't give a specific date, but she just says following her incarceration. And failed to comply with the court-ordered parenting plan. Now, who failed to comply? How was he to comply with it? You were in jail. Was he supposed to come drop the child off at the scheduled time and pick him back up at the jail? No. He didn't fail to comply. You failed to be available for him to comply because you were incarcerated. The petitioner made sporadic payments. So she's admitting here that Brian did make payments in her court document. The petitioner made sporadic payments far below the alimony obligation into the respondent's jail account. And I think there is a limit to what they can have in their account. So there's no way he could have made the full payment every month because she's not able to receive that amount, in my understanding. Further, petitioner ignored the respondent's repeated requests to communicate with her minor child and to be included in major parenting decisions, as he should. On September 19th, 2020, a case management conference was held to discuss petitioner not abiding by the court's final judgment. The court verbally instructed petitioner to resume alimony payments and comply with the parenting plan. That is a bold statement. I'm going to have to pull that up. The court further instructed petitioner's attorney to inform petitioner to adhere to the final judgment. So she's saying that the court verbally told him to resume and comply. Pause and we will look at that. All right, here's a list of the family trial scheduled hearings. So there is one on June 15th, 2018. The next one was September 19th, 2022. There wasn't anything in 2020. So maybe she's referencing this one since it was on September 19th, but she has the year wrong. So let's take a look at that document. This is the court minutes from September 19th, 2022. It says hearing held in person. Court ruling: the court will take no action on the notice for trial filed by Mr. Martel. Mr. Mendoza, who was appearing for Mr. Martel, will provide an order to the court regarding any child support being vacated temporarily. This will be solely based on Ms. Boone's incarceration. Ms. Boone completed change of address form in open court. It seems like she's steady having address issues. And that's all the minutes say. So she's saying that she remembers the court verbally instructing Brian to resume alimony payments and comply with the parenting plan. But that's not what the minutes say, and she didn't remember the date correctly. So I don't feel like this is accurate. Also, whoever typed this up for her, did you not look at the dates? And maybe it's just a typo. I don't know. All right, E. When petitioner failed to fund respondent's bank account with court-ordered alimony payment, the bank closed respondent's bank account for having a negative balance. Banks do tend to do that. Respondent contacted petitioner and arranged for a liaison to accept future payments and all arrearages. Petitioner ignored this request and threatened to hang up on her whenever respondent broached the subject. F. Therefore, petitioner continued to defy the court's order, which I still haven't seen a court order instructing him to continue the payments. I have seen a court order saying that the decision could not be made yet, so that it was in limbo. Failing to facilitate visitation with the minor child and not meet his financial obligations under the final judgment. Sarah does not mention how she is not meeting any of her obligations under the final judgment with the parenting plan, in visitation with the child, etc. G. When respondent asked petitioner via telephone and by tablet message about these unmet obligations, petitioner verbally berated the respondent, referring to her as a K and M, and laughed, mocking her incarceration by stating that there is nothing Sarah can do. Petitioner told respondent that she will be working 3 jobs for the rest of her life and that the minor child would not be allowed to see her because she will be living in a shelter. On April 11th, 2022, respondent files a motion for contempt. So see, this is out of order because the case management conference was after her motion, I believe. So respondent filed a motion for contempt. On April 12th, 2022, the petitioner filed a supplemental petition for modification of final judgment. And the filing number is here, asserting that 1, respondent's incarceration constituted a material change in circumstances. 2, the minor child had resided with the petitioner throughout the respondent's incarceration. And 3, the respondent no longer requires alimony or child support. Based on these arguments, the petitioner seeks to terminate the respondent's court-ordered alimony, child support, and parental rights. All of those things are true. J. Despite the court not approving the petitioner's petition for modification of final judgment, and as we've looked at many times, they said they couldn't rule on it until her criminal case was completed, which was 2 years later. The petitioner unilaterally had decided to not provide alimony or child support payments, leaving the respondent without financial means to secure legal representation. Furthermore, the petitioner also continues to deny the respondent communication with the minor child, visitation rights, and exclude her from all parental decision-making. Please see Exhibit A, sample of respondent's tablet message correspondence with respondent. Please see Exhibit B, respondent's virtual visitation schedule. She got all of these off of a YouTube channel, by the way, because they have a watermark on them. You'll recognize it as soon as you see them. She's saying that he unilaterally made the decision not to provide any support, but he's supporting the child unilaterally. And did she make any unilateral decisions without consulting others, like maybe causing her reason for incarceration in the first place? K. In 4/18/23, the petitioner subsequently filed a motion for continuance in response to the respondent's motion for contempt, arguing that the pending petition for modification constituted a change in circumstance under Rosenblum v. Rosenblum 2015. The petitioner asserted that the court could not enforce the respondent's existing alimony and parental rights while the modification motion remained unresolved, which they just had the hearing for in August of 2025. However, the change in circumstances was solely due to the respondent's situation, yes, and not related to the petitioner's financial inability to meet his court-ordered obligations. That doesn't matter. This is moot. This does not matter. It is solely due to your situation because you had a significant change in circumstances. It didn't say, was there a change in circumstances on both sides significantly? That's not the rule. That's not what they're ruling on. If that were the case, if that were the requirement, the court would have just denied it and said, well, there's not been a significant change in circumstances on both sides. And then they would have made the ruling. That's not what they did. L. 4/19/23. The court granted the petitioner's motion for continuance regarding contempt charge. So they granted the petitioner's motion for continuance regarding Sarah's contempt charge, which is not a charge, it's a motion. But M. Petitioner's failure to pay court-ordered alimony has left respondent without the financial means to retain legal counsel. Further, respondent has no ability to purchase writing utensils, stamps, and envelopes. Again, a result of the decisions petitioner has made. And respondent asked the court to provide access to tablet messages, recorded phone calls, and is denied by court, stating it is irrelevant. Oh, on 3/12/25, the respondent received a court notice requiring her to appear for discovery. Oh, she did receive the court notice on 3/12/25 that she just stated she never received in her previous communication. So she did receive it on 3/12. It says she received a court notice on 3/12/25, requiring her to appear for discovery pretrial proceedings via a scheduled case management hearing on March 26, 2025 at 9:30. 2. To reconsider contempt of court continuance and to sanction petitioner and his counsel. Comes now the respondent, Sarah Boone, and respectfully moves this honorable court to reconsider the contempt of court continuance awarded to petitioner and to sanction petitioner and petitioner's counsel. A. Reconsideration of continuance. Petitioner filed a motion for continuance on respondent's motion for contempt of court, arguing that the pending petition for modification constituted a change in circumstances under Rosenblum v. Rosenblum. Petitioner incorrectly assert that the court cannot enforce respondent's existing alimony and parental rights while the modification motion remains unresolved, despite the fact that the alleged change in circumstances is solely related to respondent and not to petitioner's financial ability to meet his obligations. That is what the court ruled, because he filed his motion before you filed your motion for contempt, and they said they had to hear his motion first. We've been over this many times. 2. Petitioner's reliance on Rosenblum v. Rosenblum is misplaced. Oh. That case held that a party cannot be held in contempt if they lack the ability to pay. However, Rosenblum requires a showing of financial incapacity, not merely a change in circumstance of the receiving party, such as incarceration. Here, petitioner has failed to assert or provide any evidence of financial hardship. His argument is legally and factually deficient. That is a bold stretch from her. I think her understanding is lacking, because the judge said, legally, we cannot hear your contempt until we hear his motion for modification. 3. Florida law mandates compliance with court orders unless a modification is officially granted. But he filed the modification and they can't rule on it until after your criminal trial was dealt with. That's why it was on pause. In Department of Revenue versus Jackson, the Florida Supreme Court reaffirmed that support obligations remain enforceable until legally modified, and he did file a legal motion. Tyndall v. Tyndall further establishes that a party may not use procedural delays. Let's listen to our own advice, Sarah. To evade enforcement. Thus, petitioner's attempt to circumvent his obligations by invoking an unsubstantiated legal argument is improper and should not serve as a basis for continuance. B. Willful noncompliance and contempt. 1. Petitioner has continuously failed to pay alimony as ordered in the final judgment of divorce. A willful violation occurs when a party deliberately refuses to comply despite having the ability to do so. In Tyndall v. Tyndall, the court held that contempt is warranted when a party has the financial means to comply but chooses not to. 2. Florida law provides clear authority for holding petitioner in contempt. Florida statutes grants the court power to enforce support orders in Lamb v. Lamb. The court ruled that failure to comply with a support order constitutes contempt if the obligated party has the financial ability to pay. Petitioner has not presented any credible evidence of financial hardship. His refusal to comply without justification constitutes deliberate contempt of court. Except that the court ruled that they were not going to make a ruling on that until after your criminal case, and they said that it was on pause. The court ruled that in your case. So you need to quote Boone v. Boone. You need to go back in your court docket and quote Boone v. Boone, because that's what's relevant to this case. Under Bowen v. Bowen, a party seeking relief from contempt must prove an inability to pay. Petitioner has failed to do so. His continued noncompliance is unjustified and should not be excused. He's not claiming ability or inability to pay, though. He's claiming that there's a significant change in circumstances, aka your incarceration. 4. Petitioner and petitioner's attorney are using respondent's incarceration and lack of financial resources to deny her constitutional rights. Under Florida Rule of Civil Procedure and Florida Family Law Rule of Procedure, a party may be held in contempt for failing to comply with court orders or for conduct that intentionally impairs the opposing party's rights. Moreover, the Florida Supreme Court has long recognized that due process and access to the courts are fundamental rights, even for incarcerated individuals. By using respondent's incarceration as a means to deny her access to justice, petitioner and petitioner's counsel are acting in bad faith and in violation of Article 1 of the Florida Constitution, which guarantees the rights of all persons to access the courts without obstruction. No one is obstructing you from accessing the court. You access the court a whole lot. Therefore, respondent requests this court to sanction petitioner and their counsel, compel compliance with all legal procedures, and uphold respondent's constitutional rights. C. Petitioner's motion for modification lacks merit. 1. Petitioner's motion for modification of alimony, child support, and custody should be denied as he has failed to demonstrate a substantial change in financial circumstances. But that's not what he's claiming. He's just saying there's been a significant change in all circumstances, not financial specifically. Under Bowen v. Bowen, any modification requires clear and convincing evidence of financial hardship, which petitioner has not provided. You already said that. 2. Florida law is clear that incarceration alone does not justify modification of parental rights or obligations. Hunter v. Hunter rejected the notion that incarceration by itself is sufficient grounds for modification of custody. Perez v. Perez further confirms that unilateral denial of parental rights violates Florida custody laws. Petitioner's motion is legally unfounded and should be summarily denied. D. Sanctions for petitioner and his counsel. 1. Petitioner and his counsel have engaged in bad faith litigation tactics. Really? By filing a meritless motion for continuance, thereby causing unnecessary delay and confusion. You're the only one confused. Florida Rules of Civil Procedure authorize courts to sanction parties who engage in improper litigation conduct. Florida statutes provides for sanctions against parties who willfully violate court orders. In Martinez v. Martinez, the court sanctioned a party for meritless delays and failure to comply with an alimony order. Do you really want them to look at this case about meritless delays, Sarah? You really want that? Similarly, Florida statutes authorizes an award of attorney's fees for unnecessary prolongation of litigation due to baseless motions. Again, you need to strike this whole thing out. You need to strike it out. You're citing something that's going to come back on you. 3. Given that petitioner failed to obtain a legal modification. No, he didn't. Oh, okay. Before ceasing payments. Yeah, he did cease payments before he filed the legal modification. That is true. Given that petitioner failed to obtain a legal modification before ceasing payments, sanctions are appropriate to prevent further abuse of judicial resources. If anybody is abusing judicial resources, it ain't Brian. E. Request for attorney's fees. 1. Respondent requests an award of attorney's fees due to financial hardship caused by petitioner's failure to pay alimony, but you don't have an attorney. So what fees would you be paying? Under Florida statutes, courts may award fees to ensure both parties have equal access to justice. In Mikowski v. Mikowski, the court held that a financially disadvantaged spouse is entitled to attorney's fees to secure adequate legal representation. Respondent seeks such relief here. F. Relief requested. Wherefore, respondent respectfully requests that this honorable court 1. Reconsider its decision to grant a continuance to petitioner as his argument lacks legal merit and does not justify noncompliance with the court's order. 1. Reconsider its decision to grant a continuance to petitioner as his argument lacks legal merit and does not justify noncompliance with the court's order. 2. Deny petitioner's motion for modification due to the absence of substantial financial hardship. 3. Enforce the final judgment and underlying marital settlement and parental plan. They can't enforce that the child spends 50-50 time with you while you're incarcerated. It just makes no sense. Find petitioner in contempt of willful noncompliance with court-ordered alimony and child support obligations. 5. Impose appropriate sanctions against petitioner and his counsel for filing a baseless motion for continuance and unnecessarily delaying proceedings. 6. Award attorney's fees to respondent due to petitioner's wrongful refusal to comply with court orders. She doesn't have an attorney. She doesn't have any attorney's fee. Brian has an attorney. Brian has attorney's fees. And she's saying that she should be awarded the attorney's fees due to his wrongful refusal to comply with court orders, which the court has already said he's not in contempt, and they're not going to hear the motion on contempt. It's like if you give Sarah a boundary or a no, she doesn't hear it. She can't process it. There's something in her brain that just blocks it. 7. Grant any further relief deemed just and proper under the circumstances. I think the relief we've all been granted is your sentence of life without parole. That's the relief. 3. Motion to enforce marital settlement agreement and parenting plan. You cannot enforce the parenting plan because you're incarcerated. You can't have any time sharing. You can't have any, decision making. You can't attend anything. It's almost literally impossible. Parenting plan is motion to enforce marital settlement agreement and parenting plan for sanctions and for relief due to parental alienation. Comes now the respondent, Sarah Boone, and respectfully moves this honorable court for an order enforcing the court's final judgment, marital settlement agreement, and parenting plan, and relief due to parental alienation. A. Background and violations. Despite the clear terms of the final judgment, petitioner has repeatedly and willfully denied respondent court-ordered contact with the minor child and has unilaterally excluded respondent from major parental decisions in direct violation of the court's order. Please see Exhibit A, sample of respondent's tablet message correspondence with respondent. Please see Exhibit B, respondent's virtual visitation schedule. And we'll look at that at the end, but it's just basically her tablet messages he never responded to, and she continued to send, and then also a visitation log that shows they didn't show up for some of their scheduled visits. 1. Petitioner has engaged in a pattern of parental alienation and defamation, actively attempting to sever the bond between respondent and the minor child specifically. A. Petitioner has repeatedly referred to respondent as a effing murderer and killer while on calls with the minor child, causing the child to adopt and repeat inflammatory statements. It's not inflammatory because those things happened. You can maybe take this word out, but the rest of it is true. Against respondent. B. This conduct has resulted in severe emotional distress to both respondent and the minor child. Note how she always puts herself first. Continuing psychological abuse and violating Florida law regarding parental alienation, but she doesn't cite any law. B. Legal basis for relief. 1. Florida law is clear that incarceration alone does not automatically deprive a parent of their parental rights. A. In Hunter v. Hunter, the court ruled that incarceration in and of itself is insufficient to terminate or deny custodial rights unless continued contact is shown to be detrimental to the child. In Perez v. Perez, The court held that denying contact between an incarcerated parent and their child without legitimate justification is unlawful and constitutes a violation of fundamental parental rights. C. Florida statute affirms that both parents have equal rights to participate in their child's life unless clear and convincing evidence proves harm to the child. Now, there was a lot of clear and convincing evidence presented in the trial that is documented of why her involvement could be detrimental to the child, one might argue. 2. Florida law further mandates compliance with court-ordered custody agreements. A. Lamb v. Lamb holds that both parents must be consulted on major decisions unless an emergency exists. Does that include the other parent being incarcerated? I mean, what if the other parent is sadly deceased? Are you supposed to consult them just because there's a parenting plan in place? Are you supposed to go and consult someone who's deceased? It's like almost the same thing. B. Boone v. Boone establishes that contempt is warranted when a party deliberately refuses to comply with court orders. C. Speck v. Speck upheld sanctions against a parent who engaged in parental alienation, recognizing the significant harm such conduct inflicts on the child-parent relationship. C. Relief requested. Wherefore, respondent respectfully requests that this honorable court 1. Enforce the existing custody agreement and order petitioner to comply with all provisions of the final judgment and parenting plan. Perez v. Perez, Hunter v. Hunter established that compliance is mandatory unless the court formally modifies parental rights, which is what this whole case is about and hasn't been ruled on. They're still in the process of that. 2. Order petitioner to facilitate virtual calls between respondent and the minor child, establishing a set schedule for a minimum of 3 calls per week for the maximum allowable time, which is 30 minutes, afforded by the correctional facility. Additionally, respondent requests virtual contact on all major holidays. Normally, parenting plans has you split holidays, so all holidays is extremely aggressive to ask for, and 3 calls 30 minutes each per week, so she wants to talk to him an hour and a half per week. She already basically does that. 3. Compel petitioner to include respondent in all decision making regarding the minor child. All decision making, not just when it's able, convenient, none of that. All decision making. 4. Hold petitioner in contempt for willfully violating the court-ordered parenting plan. Compliance with custody orders is not optional, and that legal alternatives exist, such as filing for modification, rather than unilaterally denying a parent's rights. So filing for modification is a legal alternative, which is what Brian did. That is why this case is open. It's baffling. 5. Require petitioner to complete a co-parenting course and counseling focused on parental alienation and communication strategies. So he needs help with communication strategies to promote compliance with the parenting plan, which the current parenting plan is under modification right now. 6. Impose sanctions on petitioner for parental alienation, including but not limited to potential modifications of the custody agreement in respondent's favor. The court has authority to modify custody arrangements when a pattern of parental alienation is demonstrated. 7. Grant any further relief this court deems just and proper in the interests of justice and the well-being of the minor child. Obligation, child support, and recovery of property. Comes now the respondent, Sarah Boone, and respectfully moves this honorable court for an order enforcing petitioner's alimony and child support obligations, as well as the recovery of respondent's property wrongfully withheld by petitioner. In support thereof, respondent states as follows. Now, wrongfully withheld is a strong statement to me because you asked him to take possession of those things. Had he not gone over there and packed up your stuff, put it in storage, moved your car, the apartment complex would have put it out to the dumpster or the streets or donated it, it would have been gone. You never would have been able to recover it. And your car would have been towed and impounded. So you asked him, there was some kind of a verbal agreement there, is what I would say about that. But let's see what she has to say about that. A, enforcement of alimony obligation. 1, the court previously entered a final judgment requiring petitioner to pay alimony to respondent in the amount of $1,000 per month for a period of 84 months, due on the first day of each month by direct deposit to an account of respondent's choosing. 2, the final judgment provides that the alimony obligation will expire upon the death of either party at the conclusion of the 84-month term, except any arrearages. 3, these alimony payments are separate from any child support obligations and are designated specifically for respondent's financial support. She needs that financial support, according to her. 4, since respondent's incarceration on February 25th, 2020, petitioner has willfully and intentionally failed to make any required alimony payments, resulting in an outstanding balance of $61,000. Now, earlier she did admit that he made partial payments, so this is now saying that he failed to make any payments. 5, respondent has made multiple attempts to obtain payment from petitioner, who continues to refuse compliance without justification. So it's not without justification. He justified it by filing the motion to amend or modify. 6, petitioner's failure to pay constitutes a willful violation of the court order as established in Tyndall v. Tyndall, which states that a violation is willful when the party has the ability to comply but refuses to do so. 7, petitioner has presented no credible argument of financial hardship or inability to pay, making his refusal a deliberate and willful violation of the court's final judgment. But he is not saying he doesn't want to pay it because he doesn't have the ability to pay. He's saying that there's been a significant change in circumstances, i.e. your incarceration, and that's why he should not have to pay, regardless of his ability or inability. That's not the argument he presented. 8, Florida statutes grants the court the authority to hold a party in contempt for noncompliance with alimony obligations. See also Lamb v. Lamb, which affirms that a party's failure to comply constitutes contempt when they have the financial ability to do so. 9, incarceration does not automatically terminate or suspend court-ordered alimony. Ginsburg v. Ginsburg held that an obligor must demonstrate a substantial and involuntary change in financial circumstances to justify modification. But that case might have been solely about financial obligation. I don't know. But incarceration doesn't automatically terminate or suspend it, but he filed a modification, which is what this hearing is about. 10, accordingly, petitioner remains legally obligated to fulfill his alimony obligations. Well, they're going to rule on that, and then we'll see if he does or not. B, enforcement of child support obligation. 1, the court's final judgment requires the petitioner to pay respondent child support in the amount of $100 per month for a period of 84 months, due on the first day of each month by direct deposit to an account of respondent's choosing. The parenting plan allows respondent to use child support payments at her discretion. 3, since February 25th, 2020, petitioner has willfully failed to make any required child support payments, resulting in an outstanding balance of $6,100. That's not true, because as we heard in the family court hearing, he had been making the $100 a month payments into the clerk of court account, and they had been holding it because there was no forwarding address or account for Sarah to receive them. So they did state that there was several $1,000s in holding in the child support account, and Brian is requesting it be returned to him. 4, respondent has made repeated attempts to collect payment, but petitioner refuses to comply without justification. 5, petitioner's failure to pay is a direct violation of the court order and constitutes contempt. 6, the Florida Supreme Court in Department of Revenue v. Jackson reaffirmed that incarceration does not relieve a party of financial obligation unless they demonstrate clear and convincing evidence of an inability to pay that is not self-imposed. So I guess by self-imposed, it would be like, oh, I just am not going to work or whatever. So she's trying to say he's evading it. But that's not the only reason. A change in financial circumstances is not the only change in circumstances. It's like she's just glossing over her whole incarceration and that he's the sole provider of the child. 7, accordingly, petitioner remains legally obligated to fulfill his child support obligations. C, recovery of wrongfully retained property. That's a bold statement. 1, respondent is the lawful owner of certain personal property, including but not limited to furniture, clothing, family heirlooms, antique Christmas decorations, jewelry from multiple generations. So now we know what the heirlooms are. Christmas decorations and jewelry is what she's claiming are her heirlooms. So a couple things here and there. 2, respondent is the lawful owner, not anymore, of a 2011 Kia Sorento with 75,807 miles. Please see Exhibit C, respondent's vehicle details. 3, during respondent's incarceration, petitioner took possession of these belongings under the pretense of safekeeping, but has failed and refused to return them despite multiple requests. So you're saying that he took them under the pretense of safekeeping, meaning you had an agreement. So it's not wrongfully retained. And where was he going to return them? Is he going to drive your car to the jail, park it there, and they tow and impound it from there because it's been sitting there? Is he going to give you a bunch of Christmas ornaments to decorate your prison cell? Are they going to allow that? No. Where is he supposed to have returned them? Just because you request it doesn't mean the jail will accept it. So that's ridiculous. 4, respondent has received unverified information, keyword unverified, suggesting that the vehicle may have been scrapped and that the contents of a storage unit, including furniture, clothing, and heirlooms, may have been sold at auction. Where are you going to put the furniture? 5, respondent entrusted petitioner to hold her property, a bailment, and petitioner had a legal duty to return it or inform you before disposing of it. Because they failed to do so, they are liable for damages. 6, petitioner's refusal to return these assets constitutes conversion under Florida law. Warshall v. Price confirms that unauthorized control over another's property supports a claim for conversion. Additionally, Florida law recognizes replevin as a legal remedy for recovering unlawfully retained property. 8, if petitioner disposed of or sold the property, his actions may constitute civil theft under Florida statute, which provides for treble damages if proven. That's ridiculous. Relief requested. Wherefore, respondent respectfully requested this honorable court, 1, enforce the alimony obligation and order petitioner to immediately pay the total amount due of $61,000. 2, enforce the child support obligation and order petitioner to immediately pay the total amount due of $6,100. 3, order petitioner to pay interest on all unpaid amounts as allowed by Florida law. 4, require petitioner to appear before the court and show cause why he should not be held in contempt for willful non-payment. Well, all he has to do is show that the court said he wasn't in contempt with the court order. 5, order petitioner to provide an accounting of respondent's property and its current whereabouts, as if you had any way to do anything about any of it. 6, order petitioner to immediately return any and all items still in his possession. To where, Sarah? To who? 7, order petitioner, if any items are no longer available to be returned, and to require petitioner to obtain independent appraisal for other missing items. So now he has to appraise missing items. How would you even begin to do that? That doesn't even seem like a reasonable thing to ask. 8, award treble damages under Florida statute if petitioner's actions constitute civil theft. And 9, grant any other relief this court deems just and proper. 5, grant a continuance on March 26, 2025 case management hearing, pre-trial discovery submission requirement, and grant attorney's fees and costs. So she's asking for a continuance, but earlier she complained about them dragging this out. Comes now the respondent, Sarah Boone, and respectfully moves this honorable court for a continuance of the March 26, 2025 case management hearing, pretrial discovery, submission requirement, and an award of temporary attorney's fees and costs. This motion is made pursuant to Florida Rule of Judicial Administration, Florida Family Law Rule of Procedure, and Florida statute. In support of this motion, respondent states as follows. A, continuance on pretrial discovery, because she's a big giant procrastinator. 1, respondent's incarceration and resulting prejudice. It's not prejudice because you're lazy. A, respondent is currently incarcerated, which has severely impaired her ability to prepare for trial, gather necessary documents, conduct discovery, and meaningfully participate in her legal defense. False. You have not used your time wisely. B, while Florida courts have held that incarceration alone is not grounds for a continuance, a litigant must be given a reasonable opportunity to participate in civil proceedings. See Carter v. Carter. Now, what do you think is reasonable, Sarah, and what other people think is reasonable are two very opposite ends of the spectrum. C, unlike the litigant in Carter who had access to outside resources, probably because they weren't a total jerk and burned all their bridges, respondent has been unable to secure her legal materials and has no access to writing tools, paper, or stamps, creating a significant barrier to her participation. And whose fault is that? Maybe you could take a page out of Carter's book, who had access to outside resources because they weren't rude to them, and you would still have people willing to help you. But you don't. You've burned every bridge, and now you need to sit on the other side of it, like Rihanna, and just stand there and watch it burn. Respondent previously requested the court to obtain discovery materials, including recorded phone calls and tablet messages, and was subsequently denied. And I'm very upset about that. They need to give her this request so it will be in the docket and I can obtain them. So this I agree with right here. Court, you need to give her these phone calls and tablet messages so we can see them all. 2, lack of access to essential legal documents. A, respondent's necessary family law documents are currently in the possession of her criminal defense attorney, James Owens. Now, how do we know that's true? Despite multiple requests from respondent and respondent's authorized representatives, Mr. Owens has refused to return these documents, making it impossible for her to prepare for trial. C, the inability to access critical materials denies respondent the right to present a full and fair defense, as emphasized in Hicks v. State. 3, inability to obtain discovery materials. A, as an incarcerated individual, respondent has no practical means to obtain crucial discovery materials such as tablet message, correspondence, financial statements, FOIA requested phone calls, and other evidence. Yes, and I don't have a way to get these either. So if you could please advise, court. B, these materials are essential to counter petitioner's claims and support her allegations of petitioner's willful noncompliance with the court's final judgment. C, Florida courts recognize that due process requires a party to have a reasonable opportunity. Yes, reasonable. That's subjective. To be heard and present a defense. State Gore v. Chillingworth. D, again, respondent previously requested the court to obtain discovery materials, including recorded phone calls and tablet messages, and was subsequently denied. 4, lack of financial resources due to petitioner's noncompliance. A, petitioner has failed to pay court-ordered alimony, leaving respondent without the financial means to retain legal counsel. Further, respondent has no money to purchase writing utensils, stamps, and envelopes. Poor her. Without an attorney, respondent cannot properly compile and submit to the necessary discovery materials within the court's time frame. Cannot or won't? Because you're laying on your bed crying about people making fun of you. C, Florida law guarantees the right of access to courts for all litigants, including incarcerated individuals. See Schmidt v. Crusoe. 5, granting a continuance serves the interest of justice. A, Florida courts have held that a continuance is warranted when a party is unable to adequately prepare due to circumstances beyond their control. These are not circumstances beyond your control, because whose fault is it that you're there? It was within your control to not commit a crime and get locked up. That was within your control. B, denying this motion would cause substantial and irreparable prejudice to respondent and violate fundamental fairness principles outlined in State Gore v. Chillingworth.
C, granting a continuance will not cause undue delay, but will ensure a fair legal process. That is just an opinion. There's nothing to back that up. B, attorney's fees and costs. 1, legal basis for awarding attorney's fees. To who, Sarah? You don't have an attorney. A, Florida statute allows for the award of attorney's fees to ensure both parties have equal access to legal representation. B, Florida courts have long recognized that financial disparity should not be used to deprive a party of their legal rights. See Rosen v. Rosen. In Bainbridge v. Bainbridge, the court ruled that an award of attorney's fees is appropriate where one party has significant greater financial resources and the other cannot afford legal counsel. 2, petitioner's noncompliance with court orders. A, petitioner has failed to pay court-ordered alimony, taking advantage of respondent's incarceration to withhold financial support, but he filed a modification. B, this constitutes bad faith and is an attempt to manipulate the proceedings to strip respondent of her parental rights without affording her the opportunity for adequate legal representation. He's not trying to strip you of your parental rights. And legal representation is your own responsibility. It's not his responsibility. 3, severe disadvantage without legal counsel. A, without an attorney, respondent faces an unfair and unjust outcome that could wrongfully deprive her of her parental rights. B, the court must consider financial disparity when determining attorney's fees. Makowski v. Makowski ruled that a financial disadvantaged spouse is entitled to a continuance in attorney's fees to ensure fair representation. C, relief requested. Wherefore, respondent respectfully requests that this honorable court grant a continuance on the March 26, 2025 case management hearing, pretrial discovery submission, requirement to allow respondent reasonable time to obtain legal representation. You're not going to obtain any legal representation. Nobody's going to represent you. And conduct the discovery. 2, award respondent temporary attorney's fees and costs to ensure her ability to retain competent legal representation. And 3, grant such other and further relief as this court deems just and proper. Finally, and respectfully, Sarah Boone, respondent pro se, dated March 18th, 2025. And then she has Exhibit A. Obviously, someone screenshotted these text messages from a YouTuber, and we can see the logo here. We all can recognize Tanika's logo. So there are some text messages where she's just like bothering Brian. I don't know what she thinks this is helping her to do, but it's just mostly like asking him about the Christmas gifts and the fish soap and all that. And then she has some logs where they were scheduled to visit a video visit and they were a no-show. So like on Christmas 2022 and basically a couple other dates and then her car details. So that's all that was filed in this motion. Now on our timeline, if you're following along in this video, we've gone over the 2 or 3 things filed in 2024, the motion for court orders that Sarah wrote, the court's order denying motion for court orders by Judge Michael Dean. Sarah wrote a request in June of 2024. In February 2025, they had sent out the notice for non-jury trial, a cover sheet, which mentioned a motion granted to dispense with mediation. On February 26th, they had the order setting case management conference via Zoom for 3/26/25, which was what she was just requesting a continuance for. And this is the first appearance of Judge Jackson. Then Sarah had a motion to appear by phone. We saw the return mail sent to Sarah. And then we just read this motion from Sarah. Now, next, we'll see the petitioner's response to pro se motion by Sarah. And then the next day, Sarah withdraws her previously submitted motion and files a new motion. Those are going to be very lengthy. So since this video is already an hour and a half, I'm going to stop it there. Please make sure to check out the interview that I did with Kenneth Waddell. He is raising a young child whose mother is incarcerated awaiting trial. She's looking at a life sentence, and he talks a lot about how phone calls work and communication with her mother. So it's a very interesting interview, and I'll link that in here. Also check out the post tab because there are some boonies that I've posted that I want you to help me caption, and I'll compile into a video over the next couple of weeks. So we will continue this family court debacle here, but we have quite a few documents in 2025. As you can see, we still have 2 pages, and then of course they had the hearing and the court minutes, and we're still awaiting. They had their closing arguments, which I've already covered in a video when they first came out, and then we will go over the final order when it drops. But I want to thank you all so much for watching. I will see you in the comments.